Many clients come to my office and they have a stack of papers from a letter writing campaign between their prior counsel and another attorney or the other side where they say, nothing came of this. I spent hundreds if not thousands of dollars, and all that happened is they wrote letters back and forth and maybe there's an agreement reached, but everything fell through. To me, the saddest thing about that is that there was no lawsuit filed. If there's a lawsuit filed with the backstop of litigation and with the thundering cloud of a trial moving and advancing steadily forward, settlement is a beautiful thing, because settlement, with that backstop of litigation in place and with a case number in hand, any settlement that's reached has the force as if a judge or a jury decided it. Without that case number, without the lawsuit, without a filed complaint, you have nothing more than a breach of another agreement. And then you'd have to go still into the lawsuit, still into the discovery, the depositions, the trial, everything that costs so much and gives attorneys a bad name as far as the expenses. So what I suggest is shoot first, ask questions later. We already know that by the time you as a client are in our office, the problem is not resolvable on a client to opposing party level, and then an attorney is necessary. So for the $435 of hard costs that it costs to file with the state court, with the $70 that most servers take to do up to 3 attempts at service of a summons and a complaint, and the amount of money is to have an attorney spend a couple hours drafting a complaint and getting all the other accoutrement of documents that need to be filed, that's the best way to start your litigation. Because at that point, you have something that if you reach a settlement agreement and you propound discovery along with a demand letter for settlement, even if there's payment plans involved, right at the inception, instead of a defendant lawyering up, oftentimes you can encourage them to enter into a settlement or a payment plan or the terms that are sensical and make sense for all parties involved. So that's just another example of what we do to manage litigation costs.